The gentleman from Virginia, Mr. Scott.
Thank you, Mr. Chairman. Mr. Chairman, as a member of the Virginia congressional delegation, I take great pride in the contributions of those from the Commonwealth who have made to ensure the viability of our constitutional form of government. Washington, Jefferson, Madison, Mason, and others were Virginians who led the development of our constitutional form of government and endeavored to protect and defend it. In that great tradition, a former member of this committee, fellow Virginian Caldwell Butler, is someone I hold in very high regard. As a Republican, Mr. Butler faced the daunting prospect in 1974 of voting to impeach a president of his own party. After a fair process, he was looking at overwhelming evidence of the president's guilt and had the courage under those circumstances to vote to impeach the president of his own party. Unfortunately, Mr. Chairman, this party has neglected its sobering constitutional responsibilities and is engaged in an unprecedented substantive and procedural abuse of Congress's impeachment powers. Since the beginning, a number of colleagues and I have called for a fair, expeditious, and focused process. Such a process would have first specified the allegations. It would have then established a standard for determining which, if any, of those allegations constituted an impeachable offense. If any of the offenses were alleged which might constitute an impeachable offense, the process would then have determined with a presumption of innocence whether those allegations were true by using cross-examination of witnesses and other traditionally reliable evidentiary procedures. If any such impeachable allegations were determined to be true, then we would judge whether they had the substantiality to justify the removal of the president from office. We did not proceed in such a logical, constitutionally reverent process. Instead, we dumped mountains of salacious, uncross-examined, and otherwise untested materials onto the internet, then started sorting through boxes of documents to selectively find support for a foregone conclusion. Our first step in a logical process should have been to look to determine whether or not, even if true, some of those allegations might constitute impeachable offenses. This committee has completely gutted our impeachment precedents. We have been warned repeatedly that these allegations are nowhere near what is necessary to overturn a national election and to impeach a president. Despite these cautionary flags, this committee has turned a deaf ear to hundreds of years of precedents and to the Constitution that has kept this country strong and unified. Mr. Chairman, we did have a hearing at which we considered the constitutional standards for impeachment. At that hearing, scholars told us that there was no constitutional authority to impeach a president simply because we dislike him or because we disapprove of his actions, when those actions do not constitute treason, bribery, or other high crimes and misdemeanors. In fact, by proceeding with an inquiry based on allegations that do not meet that high standard, we have done irreparable harm to our system of government by establishing a dangerous and partisan impeachment at will precedent that will forever weaken the institution of the presidency. The presidency was intended to be free from subversion by the legislature. 3 separate and co-equal branches were envisioned by the drafters of our Constitution, and it is this reason that impeachment is limited to the constitutionally explicit treason, bribery, or other high crimes and misdemeanors. Impeachment was to be a mechanism to protect us against conduct, as described by Professor Ackerman yesterday, that constitutes a threat to the very foundation of the Republic. We know from the Nixon impeachment proceedings that it does not cover $500,000 income tax fraud. In fact, at our hearing, we heard that all of the scholars agreed on one panel, 10 of them, that treason, bribery, or other high crimes or misdemeanors does not cover all felonies. And so it was not intended to be a crafty way for Congress to be able to remove a president based on a standard of no confidence. Furthermore, Mr. Chairman, at the hearing, when I posed the question of whether any of the witnesses on the hearing's second panel believed that the count involving invoking executive privilege should be considered an impeachable offense, the clear consensus on the panel was that the charge was not an impeachable offense. In fact, one Republican witness said, I do not think invoking executive privilege, even if frivolously, and I believe it was frivolous in these circumstances, but that does not constitute an impeachable offense. In addition, scholars have refuted attempts by impeachment supporters to argue that the last three impeachments support lowering the impeachment standard to impeach President Clinton for, quote, perjury, despite the fact that all of these impeachments involve judges and the effects of their actions alleged to have had on their offices, and the fact that two of the judges were actually in prison during their impeachment trials. Impeachment cases of Judge Claiborne and Judge Nixon were referred to several times as representing private conduct. However, both of those were tried, convicted, and were in prison for crimes when evidence was that Judge Claiborne had lied about on his income tax return for not including funds received from bribes, and Judge Nixon for lying about contacting a prosecutor to influence a drug case of a business associate. Mr. Chairman, if we are to impeach the president, it should be at the end of a fair process. But these decisions we've made in the last few weeks have been made on a strictly partisan basis. Campaign finance reform was put into play by the committee on a party line basis, but news reports indicate that it was taken off the table by a strictly partisan phone conference without any discussion with Democratic members. Likewise, there was no involvement of Democrats in either the issuance or deadline set in the 81 questions posed to the president. Neither has there been any discussion as to standard of proof to be applied, and no discussion about the apparent presumption that uncross-examined testimony from witness questions by one side would be sufficient to require the president to prove his innocence. Instead, without any process for determining which, if any, of the allegations, even if true, would be impeachable, we have wandered blindly through an inquiry without any specific allegations or scope. The accused should have at least some reasonable notice of the charges against them. Mr. Starr started out with 11 allegations and came back with 10. Republican counsel said 15. Mr. Hyde, a couple of days after that, said we should have 2 or 3, but didn't say which they should be. Some Republican members, including the chairman, essentially dropped one count or another because they did not seem to be significant. Others have been adding charges this very week. Mr. Chairman, we finally have what are supposed to be the definitive allegations, the articles of impeachment, but they were not available to the President's counsel yesterday when he was asked to respond to the charges. And we had the spectacle this morning of watching the Democratic counsel try to defend the allegations without knowing the specifics behind the articles of impeachment. Mr. Chairman, at the end of a fair democratic process, the president might very well have been impeached by a bipartisan vote of this committee if substantial actual evidence had been considered. But instead of following a reasoned approach, we have subjected the committee to ridicule and scorn. And so here we are on the verge of impeaching a United States president, overturning a national election, plunging our nation into constitutional crisis in contradiction of everything the Founding Fathers labored to avoid on a totally partisan basis. And so, Mr. Chairman, I do not have the heart-wrenching decision that former Congressman Caldwell Butler faced, who found himself at the end of a fair process, facing overwhelming actual evidence of guilt of the president and actual offenses which were clearly impeachable. I find myself facing allegations which most scholars agree would not be impeachable, even if they were true, and allegations which are presented to us by way of contradictory, uncross-examined hearsay and dubious inferences. Under these circumstances, it is totally inappropriate to vote to remove the president from office. I yield back the balance of my time.
Mr. Inglis, the gentleman from South Carolina.
Thank you, Mr. Chairman, and I want to join with others in thanking you for the way that you've conducted these proceedings, and congratulate you on the demeanor with which you've conducted them and the fair way in which you've conducted them. Obviously, my point of view differs considerably from the gentleman who just spoke. What I'd like to do, Mr. Chairman, is talk about three things. Talk about truth, talk about principle over convenience, and talk about our constitutional obligation. First, it seems to me that what we're witnessing here is a conflict, a clash between two very different views. One view is that there is absolute truth. The other view is that everything is relative. And this is not new. This is not a new debate in this country. It's actually been going on quite a while. Most of us on this committee are lawyers. And remember that Oliver Wendell Holmes sort of established the school of legal realism, which basically said, let's abandon the search for truth and let's do relative justice between people, because there is no truth out there to find. That was a significant statement and set us on a significantly different course in our legal tradition than where we started at the foundation of the country. And really, what we're seeing in President Clinton, I believe, is the culmination of that. He is the perfect embodiment of everything being relative. He is the epitome of someone who says there is no truth. Everything is relative. And that's the big conflict here. For those of us who believe that there's truth, that telling the truth is crucial, and that there are right statements and there are wrong statements, we find it incumbent upon us to act. For those who are willing to dismiss, well, it was a lie in the case of sex, so therefore it's not a real lie, it's a little lie about a little matter. They take the opposite view and say, you surely can't impeach a president for something like that, because relatively speaking, it's not as bad. So there are around us some vestiges of this old system of absolute truth. We had a witness here, Steve Salzberg, who taught me evidence at the University of Virginia Law School. And at UVA, we have something called the Single Sanction Honor Code. If you lie, cheat, or steal, you're gone. Single sanction. No intermediate sanctions, no disciplinary actions against you. If you commit any of those infractions, you're gone from Mr. Jefferson's academical village. That's an old view. And the reason I mentioned Mr. Jefferson, is he said, we hold these truths to be self-evident. Now let me rewrite that in the way that the White House spin machine would write it. We hold these relativistic moral assertions to be relativistically true. They work for me, see if they work for you. That's the way the White House spin machine would rewrite the preamble to the Declaration of Independence. But Mr. Jefferson said, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. Among these are the right to life, liberty, and the pursuit of happiness. So for those of us who take that view that Mr. Jefferson was right, we come upon a guy, William Jefferson Clinton, who asked us to believe that alone depends on the geographical definition of alone, and is depends on how you define the word is, and all of these other hair splittings, and we say, this is unacceptable. Now, I understand there are others who don't take that view. They want to usher us into this relativistic age. They want to push on Oliver Wendell Holmes' ideas. They want legal realism to be the rule of the day. They want a very different rule than where we started in this country. But I, for one, hope that we reassert here at the end of this millennium, in the beginning of the next, that truth matters, that it matters whether the President of the United States lied or not. That, I believe, is the real question behind this. Now, there's a lesser question there, too, not quite as high as a question of truth as opposed to relativism, which is the rule of law. And there, what we're looking at is, for those of us who believe in true truth, absolute truth, we believe that the rule of law is crucial. There are those that take a different view, and they're willing to excuse this breach of the rule of law. Perjury is a crime that I believe undermines the very basis of our judicial system, the very basis of the rule of law, and we've heard that repeatedly from witnesses before this committee. So the first issue, I think, is truth. The second issue, I think, before us is the issue of principle over convenience. Now, we've heard a lot of discussion from the other side, particularly, and from the White House counsel, about how the economy could suffer, about how legislation may be held up, about how the Supreme Court's activities may be held up if we go forward with a trial. And of course, they also tell us that polls, for the moment, tell us that the president shouldn't be impeached. But you know, those same polls said that Richard Nixon early on shouldn't be impeached, although at this point in the process they had turned. Polls early on told George Bush not to go to the Persian Gulf conflict. But he led, and I believe it's incumbent upon us to lead, even in the face of that. Because you know, in 1992, when I first ran for Congress, we had a wonderful volunteer, a college student, who proudly brought in a T-shirt to the campaign office that has a slogan that many will recognize: a politician thinks of the next election, a statesman thinks of the next generation. And here, rather than studying the polls and figuring out what we should do about the next election, I think we must think about the next generation and decide that we are going to establish the principle, or really restate the principle here at the end of this century, that truth does matter. And it's important to state that even if it causes short-term inconvenience by the way of interruption of legislation or the interruption of the function of the Supreme Court, because this is an important matter. The third thing that I think is important to point out here is that we have a constitutional obligation to act. And there are a lot of folks who would counsel, listen, let's just move along. It's sort of the Clinton so what defense. So what? I committed perjury. So what? I broke the law. Let's just move along. I believe we've got a constitutional obligation to act. And of course, there are those that overlook that constitutional obligation, and they refer again to the polls, and they say, but look at the polls. In a pure democracy, of course, you can do anything as long as you've got a majority. In fact, if there are more Baptists than Roman Catholics, the Baptists can vote that there will be no masses on Sunday. In a pure democracy, that is completely acceptable. But thank goodness we're not a pure democracy. We're a constitutional republic. And in a constitutional republic, we are constrained by principles set out in the Constitution. And those principles, I think, call on us in this case to act against the President of the United States and to punish his perjury and to act against his obstruction of justice and to say that we will not tolerate abuse of power. Censure is not an option. It's an extra constitutional remedy. It can't be found in the Constitution, and the fines that are being discussed, I think we heard from a number of witnesses, would be bills of attainder, clearly violating that Constitution that I was just describing. So that means we're left with the constitutional procedure, the majestic constitutional procedure of impeachment, and I hope we go forward, Mr. Chairman.
I thank the gentleman from North Carolina, Mr. Watt.
Thank you, Mr. Chairman. There is hardly a member of this committee who has spoken up to this point, either Republican or Democrat, who has not said something with which I agree. I want to pay special tribute to Mr. Scott and Mr. Boucher because I associate myself with substantial parts of their statements. But I also want to associate myself with some of the comments that Mr. Gallagher made, because I believe, like Mr. Gallagher asserted, that without the rule of law, we have anarchy in this country. When I was in the 8th grade, one of my teachers looked at me and said, "You like to talk a lot. You must be going to be a lawyer." And there was no precedent in my family for it. I didn't really know what a lawyer was. But from that very moment, I set out saying to myself and others that I wanted to be a lawyer. And later in life, I did end up going to law school, and I started to understand what the rule of law was all about and why it was necessary. And then I went back after law school and started practicing law, and I practiced law for 22 years before I was elected to the Congress of the United States. And there I started to understand even more the importance of the rule of law. And I've seen the rule of law undermined in a number of different ways. I've seen it undermined by inequality of resources of people who come into the courtroom. I've seen it undermined by racism and bias, and have even been called by a judge in a court nigger. I've seen it undermined by the lack of due process. I've seen the rule of law undermined by lying under oath. Yes, ladies and gentlemen, it happens regularly in the courts of America, as at least one witness has said before this body. But there is not a single way that the rule of law is undermined that is more disparaging and more important than a disregard for the law and the established standards of the law. What does the law say? And that's why I was so outraged by the presentation by the majority counsel today. And I'd like to talk about 4 of the things that he said that I especially was offended by. At the bottom of page 36 and going over to page 37 of the majority counsel's statement, he said, "This is a defining moment both for the presidency and especially for members of this committee. For the presidency as an institution, because if you don't impeach as a consequence of the conduct that I have just portrayed, then no House of Representatives will ever be able to impeach again." He went on to say the bar will be so high that only a convicted felon or a traitor will need to be concerned. My friends, that's what the rule of law says. That you can convict, you can charge, you can impeach a president only when that standard is met. He said on page 27 of his written statement, "Whether the offenses of President Clinton are criminally chargeable is of no moment. This is not a criminal trial, nor is it a criminal inquiry. It is a fundamental precept that an impeachable offense need not be a criminal act." My friends, the Constitution of the United States defines the grounds for impeachment as bribery, treason, or other high crimes or misdemeanors. What does other high crimes or misdemeanors mean if it does not mean a criminal act? What do the words mean? Are we going to disregard that? At page 26 of his statement, the majority counsel said, "This is not a trial. It is in the nature of an inquest.
Any witness whose testimony is referred to in this proceeding will be subjected to full cross-examination if a trial results in the Senate. That is the time to test credibility. As it stands, all of the factual witnesses are uncontradicted and amply corroborated. I just absolutely disregard and reject that as the basis on which we should be proceeding. Think about what that means for future impeachment proceedings. Anybody who wants to start an impeachment proceeding and gets it into this committee and puts any evidence before us, we don't ever have to test the credibility of it. He couldn't possibly mean that, but that's exactly what he said the standard should be. I can't go along with that standard. Finally, on page 36 of the Majority Counsel statement, he said these words, which I vigorously agree with. One of the witnesses that appeared earlier likened the government of the United States to a three-legged stool. The analysis is apt because the entire structure of our country rests upon three equal supports: the legislative, the judicial, and the executive. Remove one of those supports, and the state will totter. Remove two, and the structure will either collapse altogether or will rest upon a single branch of government. Another name for that is tyranny. He's absolutely right. And where we are today is that we are trying to remove the executive of this country. We are about to tie up the judiciary and its chief justice in an impeachment trial in the Senate of the United States. And so the Majority Counsel apparently would have the legislative branch be the only standing leg of the stool. I don't believe that's what was intended. I reject that as a notion, and I beg of us not to take that authority and give it to the legislative branch. Let's continue to have a three-legged stool as a part of our government. Thank you, Mr. Chairman.
Thank you. The gentleman from Virginia, Mr. Goodlatte.
Mr. Chairman, this is a somber occasion. I am here because it is my constitutional duty, as it is the constitutional duty of every member of this committee, to follow the truth wherever it may lead. Our founding fathers established this nation on a fundamental, yet at the time untested idea that a nation should be governed not by the whims of any man, but by the rule of law. Implicit in that idea is the principle that no one is above the law, including the chief executive. Since it is the rule of law that guides us, we must ask ourselves what happens to our nation if the rule of law is ignored, cheapened, or violated, especially at the highest level of government. Consider the words of former Supreme Court Justice Louis Brandeis, who was particularly insightful on this point. In a government of laws, the existence of the government will be imperiled if it fails to observe the law scrupulously. For good or for ill, it teaches the whole people by its example. If government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. Mr. Chairman, we must ask ourselves what our failure to uphold the rule of law will say to the nation, and most especially to our children, who must trust us to leave them a civilized nation where justice is respected. The charges against the president include perjury, obstruction of justice, and abuse of power. These are serious charges deserving serious consideration. The question before the committee is whether the President intentionally misled our judicial system and the American people as part of a calculated, ongoing effort to conceal the facts and the truth and to deny an average citizen her day in court in a sexual harassment lawsuit. And did the President betray the public trust by perjuring himself before a federal grand jury and obstructing justice? Let's take a minute to examine the facts of this case. On January 17, 1998, the President swore to tell the truth, the whole truth, and nothing but the truth in a deposition given before a federal district judge. The President testified that he did not know that his personal friend, Vernon Jordan, had met with Monica Lewinsky, a federal employee, a subordinate, and a witness in the Jones case, in which the President was named as a defendant, and talked about the case. The evidence before the committee clearly indicates that the President lied under oath. The President testified that he did not recall being alone with Ms. Lewinsky. The evidence before the committee clearly indicates that the President lied under oath. On August 17, 1998, 7 months after his deposition in the Jones case, the President swore to tell the truth, the whole truth, and nothing but the truth before the federal grand jury. The President testified that he did not allow his attorney to claim that his affidavit in the civil case was true when he knew it was false. The evidence before the committee clearly indicates that the President lied under oath. The President also testified before the grand jury that he did not give false testimony in his deposition in the Jones case. The evidence before the committee clearly indicates that the President lied under oath. While the President's lawyers have denied the facts against him, they have not, because they apparently cannot, provide new evidence that rebuts those facts. Many of the legal scholars testifying at the request of the President have admitted that the President lied in both the Jones case and before the grand jury, but argued that those offenses are not impeachable. If the committee were to adopt that position, however, it would create a double standard that places the President above the law. Virtually every public official in America, including our nation's governors, and virtually everyone in private employment, would lose their job if they committed perjury or obstructed justice. In fact, many already have. We have had before the committee average Americans who have suffered these consequences and even incarceration because they committed perjury. And as more than one witness testified before this committee, a person with those charges against them would not even be nominated for a position in state or federal government. If we truly respect the presidency, we cannot allow the President to be above the law. Millions of law-abiding Americans from all walks of life, including my constituents, put in an honest day's work, follow the rules, and struggle to teach their children respect for the law and the importance of integrity. When a factory worker or a medical doctor or a retiree breaks the law, they do so with the knowledge that they are not above the law. This same principle must also apply to the most powerful and privileged in our nation, including the President of the United States. To lose this principle devastates a legacy entrusted to us by our founding fathers and protected for us by generations of American families. Some of my colleagues have decided that a resolution of censure is the only appropriate remedy for the President's actions. Their resolution admits that the President made false statements concerning his reprehensible conduct with a subordinate and wrongly took steps to delay discovery of the truth. For those who might support this resolution, I would like to raise two key points. First, censure would set a dangerous precedent without foundation in the Constitution. Second, if you truly believe the allegations contained in the censure resolution, how can you not vote to impeach? The evidence against the President shows clearly and convincingly that he committed perjury and obstructed justice, and the consequences of ignoring the facts in this case for simple political expediency or of adopting an unconstitutional and ineffective censure resolution far outweigh the consequences of moving forward. I have a constitutional duty to follow the truth wherever it leads. The truth in this case leads me to believe that the President knowingly engaged in a calculated pattern of lies, deceit, and delay in order to mislead the American people, impede the search for truth, deny the right of his accuser to have her day in court, and protect himself from criminal prosecution. Therefore, I have no alternative but to support articles of impeachment against President Clinton. Mr. Chairman, I would like to thank you for the way in which you have conducted this inquiry. It has not been easy. Your fairness and dedication to duty has been rewarded by personal attacks from the White House. Throughout this process, you have remained faithful to your oath of office and to the Constitution. That is what history will remember, and that is what each of us should strive to follow. When called to duty, you rose to the occasion, and we thank you. The decision I have reached, while a sobering one, is, I believe, also the correct one. I have heard from many constituents who are deeply concerned that action be taken in this matter, and I appreciate them sharing their thoughts. One of those constituents is a 12-year-old sixth-grade student from Lincoln Middle School in Lynchburg, Virginia, named Paul Inge. He recently wrote, "I am a Boy Scout who is concerned about the leadership of the President of the United States of America. It is my understanding that other ordinary citizens who lie under oath are prosecuted. The President should not be any different. He should also have to obey the laws. As a Boy Scout, I have learned that persons of good character are trustworthy and obedient. I feel that the character of the President should be at least as good as the leaders that I follow in my local troop and community. Is this too much to ask of our country's leaders?" The precious legacy entrusted to us by our founders and our constituents is a nation dedicated to the ideal of freedom and equality for all her people. This committee must decide whether we will maintain our commitment to the rule of law and pass this precious legacy to our children and grandchildren, or whether we will bow to the political pressure for the sake of convenience or expediency. Much of our hopes and dreams for our children like Paul Inge and for the integrity of our nation depends on the answer to that question. Thank you, Mr. Chairman.
Thank you very much for your very generous remarks. The gentlelady from California, Ms. Lofgren.
This is a sad day in our nation's history. Unfortunately, it seems to be one more day in a long, sad season. We have finally reached the logical conclusion of what happens when a legislative chamber is obsessively preoccupied with investigating the opposition rather than legislating for the people who elected them to office. We now consider removing the President of the United States from the office to which he was twice elected and barring him from ever holding office again for misconduct that is hardly a high crime or misdemeanor. For more than 200 years, a directly elected chief executive has been one of the great distinctions between our wonderful country and parliamentary democracies. That is why, unlike so many other countries, we don't have a rapid succession of governments one after another, as votes of no confidence drive out prime ministers who hardly have time to govern before they must stand for re-election. Our system of government and its stability has contributed to our success. But this system needs checks and balances. The founders were well aware of the tyranny of the crown, so they established a legislative safety valve against a tyrannical executive, a process of impeachment by which they could remove the president if his conduct subverted the government. The founders designed this safety valve for abuses so grave that, in Ben Franklin's words, they suggested assassination as the remedy. Impeachment was our founders' civilized substitute. That may explain why, after more than 2 centuries' experience in this novel democratic experiment, the United States of America, not a single president has been impeached and convicted. The people's will must not be overridden by those who claim to know better, by those who believe they know what is best for the American people. The people's will may only be overridden and the government overthrown when the acts of the chief executive truly threaten our democratic institutions with injury to the state and to the people. In other words, when the threat the president poses is so great that we can't wait until the next election to remove him. A vote to impeach, therefore, must not merely pass the buck to the Senate for the real trial of the matter. A vote to impeach must be treated for what it is, a vote to remove the president. No one should consider it permissible to vote if he is not prepared to make the case that the president should be removed, not just tried, and no such case has been made here. We have heard much of the seriousness with which our courts must take the issue of perjury. No one questions that perjury is wrong, illegal, and a problem in our judicial system. But alleged acts of perjury by the president in private, non-governmental civil litigation and covering up afterwards, as terrible as that is, does not threaten our democratic system or compromise our country's vital interests. Do not misunderstand. I do not condone the president's misbehavior. I'm only saying that impeachment is not the remedy for the president's misconduct, even if criminal. For that alleged criminal misconduct, we have courts. Indeed, the course of action the majority proposes here punishes the nation rather than the president. Under President Clinton's leadership, our country has prospered, but we still have serious matters to deal with, including public education, Social Security, Medicare, and abuses by HMOs. We've had foreign policy success, but we still face challenges abroad, including the continuing financial and business crisis in Asian countries that has already been felt here and may get worse. The impeachment process may compromise our ability to deal with these problems. If the House adopts articles of impeachment, all three branches of government will be gridlocked in the Senate trial for as long as a year. The bipartisan action and cooperation needed to deal with America's problems will be drowned by this process while our people's needs are ignored. Impeachment of President Clinton, even if it does not result in conviction in the Senate, will weaken the executive branch of government and further divide this nation. We have no precedent nor evidence that justifies placing this nation at such risk. Today, I take my solace not in what we are about to do, but in my belief that the American people get it. No, not every person knows the specific constitutional provisions at issue, but they know their government. They know what's important. They knew the president they elected. They know what he's done. They know he's behaved badly, but they don't want him removed from office. They want him censured. It's that simple. Like the Constitution that established this government, the American people value freedom and despise tyranny. We have impeachment to correct the tyranny of the executive department. But what remedy do we have for legislative tyranny? Only this: the 2-year terms we serve and the electoral accountability at the end of that term. For those who are out to get the president, shame on you. But beware, next election, the voters will be out to get you. How did we get to this point? Our president behaved badly and irresponsibly in this affair with Ms. Lewinsky, but his irresponsibility does not license us to act irresponsibly, to fail to adhere to our own oaths to support and defend the Constitution of the United States. Like the Republicans who voted for impeachment in 1974, I would vote to impeach if the acts at issue here threatened our democracy. But in the absence of evidence that President Clinton committed acts that threatened the continuation of our democracy and its institutions, it is my clear constitutional duty, pursuant to my own oath of office, to oppose these reckless efforts to impeach the president. And I yield back the balance of my time.
I thank the gentlelady. The gentleman from Indiana, Mr. Booyer.
I thank the chairman. I couldn't help but, as I try to be a good listener to each of my colleagues' statements, I wonder at times if we come from the same world. You know, there are people out all across America every day that help define the nation's character, and they exercise common sense virtues, whether it's honesty, integrity, promise-keeping, loyalty, respect, accountability. They pursue excellence. They exercise self-discipline. There is honor in a hard day's work. There's duty to country. Those are things that we take very seriously. So those are things that the founders also took seriously. Yet every time I reflect upon the wisdom of the founding fathers, I think their wisdom was truly amazing. They pledged their lives, their fortunes, and their sacred honor to escape the tyranny of a king. They understood the nature of the human heart struggles between good and evil. So the founders created a system of checks and balances and accountability. If corruption invaded the political system, a means was available to address it. The founders felt impeachment so important it was included in 6 different places in the Constitution. The founders set the standard for impeachment of the president and other civil officers as treason, bribery, and other high crimes and misdemeanors. The House of Representatives must use this standard in circumstances and facts of the president's conduct to determine if the occupant of the Oval Office is fit to continue holding the highest executive office of this great country. I concur with the premise that the crimes alleged against the president may not directly involve the derelict exercise of executive powers, except the issues of possible misuse of executive privilege. The alleged crimes plainly do involve the derelict violation of President's executive duties. The committee received testimony on American and English history and legal scholarship on precedents which made plain the personal misconduct, violations of trust, and other charges of a more private nature can be impeachable offenses. The question before the committee is perjury to conceal private misconduct and other wrongful conduct to thwart and impede the justice in a civil rights case in federal court, and efforts to obstruct justice in a criminal proceeding, and perjury before a grand jury rise to the level of an impeachable offense? When the President had the opportunity to tell the truth, the whole truth, and nothing but the truth, he lied. Before the court in the Jones deposition, the President lied. Before the court in the Jones case in answers to discovery interrogatories, the President lied. Before the grand jury, the President lied. Before his cabinet and senior aides, the President lied. Before the Judiciary Committee of Congress in the answers to requests for admissions, the President lied. Before the American people, the President lied. What are the consequences if this committee leaves a known perjurer in the Oval Office? First, perjury and obstruction of justice drive a stake in the heart of the rule of law. When the Constitution was ratified, it was christened as the Grand American Experiment. America stood alone in being governed by the rule of law, as opposed to the rule of kings, tyrants, czars, monarchs, emperors, chiefs, sheiks, lords, barons, and lords, and even nobles. To our founders' credit, they created a republic based on the rule of law rather than a nation being based on the whims of man. The American legacy is that we have become the beacon of liberty to nations around the world who seek systems of government just like ours. We have an obligation to preserve the heritage of the rule of law now and for future generations. The President's lawyers give us a fantasy defense. The President's defenders would have us believe that the President's misconduct was only private and therefore not impeachable. If the President's verbal engineering prevails, then an evasive, incomplete, misleading, and even maddening statement is not a lie. No one is ever really alone in the cosmos. Is not a state of being. A person performing a sex act is having a sexual relations, but the person receiving the sexual favor is not having sex. And a cover story is not a concocted rendition of an event with the willful intent to mislead others by lies, but instead, a cover story is a simple, harmless revision of a historical event. This is neither believable, reasonable, rational, nor acceptable. The President's defense is completely misguided in its interpretations, parsing, and hair-splitting of words. C.S. Lewis called this technique, quote, verbicide, the murder of a word, end quote. When plain-spoken English language is twisted into the vague and ambiguous, society is devoid of trust. It undermines our social interactions, commerce, indeed the rule of law and government itself. I believe in civility and self-evident truths as a statement of stable social order under the rule of law. If the President's view of non-truth prevails, we set a double standard. The presidential perjurers in the future will have no consequences to face. Everybody else could go to jail. We will also set a double standard with regard to the behavior of the chief executive and as commander-in-chief. Conduct that would strip an admiral or general of his position, land a sergeant in prison, or deprive an administrative nominee of a cabinet post is condoned for the President. Our soldiers, sailors, airmen, and Marines will be bound by the high ethical code, which they should be, but our President as Commander-in-Chief, who has the power to send them into harm's way, can conform his conduct to a lower standard. I disagree. Leadership is by example and setting the higher standard. Retired Admiral Edney, who teaches ethics at the Naval Academy, came before this committee and testified, quote, dual standards and less accountability at the top will undermine the trust and confidence so essential to good order and discipline in the military. I believe the office of the President is one which has reposed a special trust of the American people by virtue of having gained the majority of the American people's electoral vote. If the President can lie repeatedly without remorse with regard to his personal conduct, can the President be trusted by the American people, by Congress, by foreign governments to conduct the official business of the United States? The trust given the President by the people, I believe, has been broken and betrayed. The President is no longer entitled to the benefit of the doubt as to his actions and his judgments, such as the use of military force and his foreign travel on behalf of the people of the United States. He is now second-guessed by everyone in coffee shops all across this country. If this committee cannot bring itself to impeach a perjurous president, the bar will be raised for future circumstances that the House and this committee might face. Our children and grandchildren will face presidents who seek to flout the rule of law in a more ambitious manner because of the precedent set through inaction. I will defend the Constitution and serve as a protector of our national heritage and help define our nation's character. I will not cave in and permit our nation to be ruled by polls, emotion, or a distortion of words by verbicide. An ancient Greek philosopher stated, "A man's character is his fate." I am saddened and disappointed that the character of President Clinton brings us to an impeachment vote for only the third time in over 200 years. We are debating articles of impeachment today not because of any partisan spite or overzealous prosecutor, but because of the truth about the President's own actions. As difficult and wrenching as this matter is, this committee must do its constitutional duty and report articles of impeachment to the full House of Representatives for the sake of our Constitution, for the sake of our children, and for the sake of our country. I yield back the remaining balance of my time.
I thank the gentleman and the gentlelady from California, Ms. Waters.
Thank you very much, Mr. Chairman and members of the committee. As a member of Congress and this Judiciary Committee, the House of Representatives, I have been thrust into a role I never envisioned. The actions of the past few weeks have caused me to tremble. I woke up in the middle of the night with flashes of the struggles of my African ancestors for justice. I am reminded of the terrible sacrifices of the heroic men and women of this nation who have fought for Americans to be able to be free of a police state and to be free of intimidation and harassment. I knew I would have to fight for the rights of minorities, women, the poor, and the marginalized for the rest of my life. Never did I believe I would have to fight to protect the rights of the so-called most powerful individual of the free world. This is a sad time in the history of this nation. We are on the brink of a Republican partisan impeachment of the President of the United States of America. The articles of impeachment are not based on his undermining of the Constitution, not based on actions that threaten the security of our nation, not based on treason, bribery, or a threat to our democracy, but rather because of the blind political determination of individuals who are philosophically and diametrically opposed to Bill and Hillary Clinton and their politics. However, tyranny knows no boundaries. This impeachment tyranny by the right ignores the most profound document of our society, the Constitution of the United States. It further disregards and disrespects the basic rights of the accused. This right-wing driven assault on our Constitution poses a clear and real danger to our future. If the architects of this anarchy win, we surely place the rights of all American citizens at risk. After reading the independent counsel's referral, reviewing the supporting documents, listening to numerous witnesses, and my colleagues on the other side of the aisle, I have become more resolved to defend the Constitution of the United States and all its protections. As I witnessed the unfolding of this march to impeachment, I was jolted by the circumstances surrounding independent counsel Ken Starr's incessant pursuit of President William Jefferson Clinton. In 1994, Attorney General Janet Reno appointed Kenny Starr as the independent counsel to investigate Whitewater. Soon after, Mr. Starr's investigation extended into the death of Vince Foster, the FBI files, the White House Travel Office files. Finally, after 4 years and over $40 million later, the president was exonerated by Kenneth Starr. This revelation of exoneration was not made by way of a planned press conference, but rather Mr. Starr casually asserted the president's exoneration in his statement before the Judiciary Committee on November 19, 1998, 16 days after the November 3rd election. At this same hearing, Mr. Starr appeared as an advocate for impeachment, an extraordinary appearance. by an independent counsel whose professional responsibility is to gather the facts and evidence for the members of Congress to arrive at our own conclusion. Mr. Starr's flagrant disregard for the constitutional protection that one is innocent until proven guilty is apparent in many forms. For some time now, Mr. Starr's bias and ruthless investigative tactics have gained the attention of legislators, many civil rights groups, and citizens of this nation. No justice-loving American can respect the ill-gotten, ill-conceived, convoluted allegations based on the investigation of a private, personal, sex-related affair. Mr. Starr tripped backwards into the Lewinsky matter because everything else he was investigating yielded him nothing. Zilch, zero. Mr. Starr's obvious bias and dislike of the president, his investigatory tactics, and his flimsy case does not meet the constitutional standard for impeachment. For example, Mr. Starr had a relationship with Paula Jones' lawyer, Gilbert Davis. In fact, Mr. Starr failed to disclose that he had 6 conversations with Mr. Davis in the summer of 1997 prior to his request to extend the Whitewater jurisdiction into the Clinton-Lewinsky affair. Mr. Starr failed to disclose that Richard Porter, a law partner in his Chicago firm of Kirkland and Ellis, was doing legal work on the Paula Jones case earlier this year, including filing a brief to the Supreme Court at least 1 week prior to January 12, 1998, when Linda Tripp is supposed to have contacted Starr's office. Jerome Marcus, a Philadelphia lawyer with ties to the Paula Jones legal team, informed a law school friend who's employed by Mr. Starr of the accusations related to President Clinton's relationship with Monica Lewinsky. Mr. Marcus filed a brief with the Supreme Court in support of the Jones case on behalf of the Independent Women's Forum, a conservative organization. Curiously, this is the same organization for which Mr. Starr helped prepare a brief in the Jones case. Mr. Starr's investigations relied on illegally obtained information from Linda Tripp. Simply put, Mr. Starr came to the position of independent counsel with unclean hands by failing to disclose to Attorney General Reno his conflicts of interest when he requested an extension of the Whitewater jurisdiction into the Clinton-Lewinsky affair. Mr. Starr displayed prosecutorial misconduct. Mr. Starr's investigative tactics are unparalleled. He has subpoenaed hundreds of witnesses, creating legal bills for innocent people who had no relationship to the facts of the case, and abusing his power by denying witnesses their basic rights. Among the victims are Monica Lewinsky, who was sequestered and whose pleas for her lawyers were ignored; Monica Lewinsky's mother, who was called in to testify against her own daughter about her daughter's sexual activities; Julia Still, whose tax returns were examined, her finances investigated, and to add insult to injury, the origins of the adoption of her 8-year-old Romanian child were questioned. Rob Hill Jr., whose 80-year-old mother, 2 adult daughters, his brother, his sister-in-law, and his 16-year-old son were subpoenaed regarding Mr. Hill's misuse of political funds. Mr. Hill's 16-year-old son was served a subpoena at his high school. Mr. Chairman, I am not here to blindly support or defend President Clinton. I have opposed President Clinton on such issues as NAFTA, Fast Track, the crime bill, welfare reform, and much more. As I sit here today, and as God is my judge, if I felt Bill Clinton was guilty of impeachable offenses, I would join with the most right-wing of my colleagues to impeach him. Witness my support of the McDade-Murtha bill, where I joined a right-wing Republican in a measure that would hold federal prosecutors accountable for their abuse of power. Rather, I am here in the name of my slave ancestors to insist that the president be afforded the constitutional protections that should be available to every citizen in this country. The president is neither above the law or below the law. As members of Congress who have sworn to uphold the Constitution, we must always insist on equal and just treatment under the law. The presumption of innocence until proven guilty is central and basic to our system of justice. The right to be free from intimidating and coercive self-incrimination is at the core of our criminal justice system. I have seen too many, and I know too much about the violation of the rights of my own people. I can never remain silent in the face of injustice. Kenneth Starr's presentation of impeachable offenses is illegitimate. He has not made a credible case for perjury, obstruction of justice, or abuse of power. Finally, Mr. Starr has undermined his own investigation by his overzealous and unethical pursuit, characterized by a get Bill Clinton by any means necessary attitude. Americans across the nation are offended that a prosecutor could have unlimited powers to delve into one's private, personal life. We've heard members of Congress describe the president's actions as sickening, reprehensible, and unacceptable. However, the Constitution does not allow for the impeachment of a president because we are upset by his personal behavior. Mr. Chairman, the 19 experts who appeared before the subcommittee on the Constitution, over 400 historians, 400 legal scholars, 10 out of 12 of the nation's most respected legal minds, and the American people agree that Mr. Starr's allegations do not reach the level of high crimes and misdemeanors. The Congressional Black Caucus, under my leadership, assigned to ourselves the role of fairness cops. We dedicated ourselves to exposing abuses in the
gentlelady's time has expired. Could you wind up?
For 30 more seconds.
Surely.
We vowed to speak up and to speak out. We decided to share the knowledge and experience of our people as we have struggled to make the criminal justice system fair. This committee may vote out articles of impeachment. However, we will not be deterred in our struggle for justice. We will fight impeachment on the House floor, and we will join the fight in the Senate if necessary. The American people must realize if the president can be impeached on these unsupported charges, no citizen is safe in our country, despite the sacrifices of the gallant men and women who have fought and died to ensure freedom, justice, and equality for all.